Okay, guys, just me, Jeff Donnelly, JP Donnelly 8. Instagram JP Donnelly 8 _art _photo, or just JP Donnelly 8. Okay, so this video right here, right? As you're all aware, with the Springfield gun license situation, that case, the jury trial, blah, blah, blah. Well, as you're probably aware, I filed an appeal. Well, to actually be able to file a brief in appeals court, you need the transcript of the case that you're appealing. So because there were several motions involved with the case, I opted to file a request for the audios from every court date that I went to in relation to this case, because there was a lot of things that were said in different hearings, which were very unlawful on the part of the district attorney's office as well as the court itself. So I filed this, I believe, on May 21st. And usually it takes 24 to 48 hours to get the recordings. Like after you've requested it. Because the request then goes to the clerk magistrate. The clerk magistrate approves it, tells the company, okay, then the company sends you an email. So on the 21st, May 21st, I sent the request with the company. And then I started getting the recordings in. So I started getting the recordings in. Okay. I'm listening to them, the ones I'm getting. I get the first motion to dismiss one in. Okay, not bad, definitely shows a lot of the misdeeds. But at the time, I don't know that what the ADA is claiming is lies, because usually when you file a motion to dismiss, the district attorney's office files an opposition to the motion to dismiss, given how, stating the reasons why your motion to dismiss shouldn't be allowed, along with case law, which are previous, cases that dictate how the law is read. Well, ADA Hobbs didn't file a motion in opposition to my motion to dismiss. So at that point in time, he's quoting case law, but quoting it wrong. But I've got no idea that he's quoting it wrong. And when I say wrong, I mean he is quoting case law in exact opposition to what the law itself says and what the cases actually said. Like one of them was that he claimed that facing charges is an automatic disqualification for a firearm license. Like if you have it, it's an automatic disqualification. It's automatically revoked. And that, I believe, was Massachusetts versus Farley. Well, after the hearing, I went home and I looked up Massachusetts versus Farley, and it actually says the exact opposite. It says that just facing a charge is not is not an automatic disqualification. So if you look at it, the law itself, the case law, was in direct opposition to what he claimed. Okay, so then when you look at it, the recordings just stopped being sent to me. The last recording I received was a pre-trial conference or something. I forgot what it's called. I think it's a status hearing to pick a jury trial date, which had already been picked. But whatever, so there was still a motion to reconsider that was filed and heard afterwards. And then a few other, dates where I was really pushing, saying this is corruption and I was spelling out and showing like exactly how the ADA was lying and the judge was, acting improperly. But this right here, hearing the last one I received before they stopped giving me them, was a hearing before Justice Rook. In this hearing, she comes out and says, I am not going to entertain a conspiracy theory. And she was being extremely disrespectful and extremely rude to me. And during this hearing, I looked at her and I'm like, Your Honor, I'm like this. And I was respectful too throughout this whole hearing. I'm like, Your Honor, I'm like this. Well, we're not dealing with a conspiracy theory. We're dealing with a conspiracy because when 3 separate cases are filed within a year, and 2 of these cases, including the original one, are dismissed at motions to dismiss, and the third one, which is this one that we're sitting on, should be dismissed on a motion to dismiss. It stops being a theory and starts becoming fact-based, a conspiracy. She wasn't too happy about hearing that. She told ADA Hobbs, because she was asking about who I planned on having as my witness, as witnesses. So I had stated, and she looked at ADA Hobbs, because I planned on having the ADA Hobbs as a witness to testify. I planned on calling ADA Joyce from the Palmer case, well, the Munson case out of Palmer. And then I planned on having ADA Chavez, I believe, who was the ADA involved in the court officer case. Both of those cases, remember, were dismissed already. So I plan on having those, as well as the district attorney on the stand as well. Well, Judge Rook looks at me and says something like, well, have you summoned them to show up yet? I'm like this, not yet. And I'm like, and ADA Hobbs is going to be here anyways because he's prosecuting the case. And then she looks at them and says, well, something like, well, if he does, you could file a motion to squash it. Like, you could file a motion to squash it, meaning if he files to have you testify or any other ADA in your office testify, file a motion and I'll rubber stamp it. File a motion saying that you don't want to testify. Like, it's like, dude, like, as a judge, is this woman, is she impartial or is she, on the side of the prosecution? You have to ask yourself that. Because the judge is supposed to be completely impartial, but when they're sitting there calling me names and being extremely rude and impolite to me, when I'm being polite in front of her, first time I've ever been in front of her, it's like, look, Palmer, at least the judge over there, he dismissed the charges in a way that he shouldn't have, but he still dismissed them. And he also actually told me that I have a very high IQ and stuff, and I'm intelligent. So I got one, that I had for a jury trial like 10 years ago, who reads these motions that I've got going on and stuff, who's telling me I'm very intelligent. And then I have this woman telling me that I'm like some tinfoil wearing lunatic, even though I won the other 2 cases, and this case should have been won also. Yeah, like, so this is the last recording I received. There's about 4 recordings after, maybe 5, probably 4. Well, week before last, I stopped receiving recordings, probably around Wednesday or so, maybe Tuesday. So I called up the court, called up the clerk magistrate's office, the clerk's office, who is one responsible for putting these recordings together, or at least approving this company to issue the recordings. So what I do is I call the clerk's office, and the clerk magistrate, or whoever's working for them, transfers me to the judge's lobby. So I get transferred to the judge's lobby, and the judge's lobby has nothing to do with recordings. Nothing. It's the clerk magistrate's office that has everything to do with the recordings. So in the judge's lobby, I'm talking to someone on the phone, and she's telling me, Mr. Donnelly, you asked for a lot of video, you asked for a lot of audios, blah, 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 It's going to take us some time to get them together. I'm like, well, it's been a couple days since I've received one. And she's like, well, you'll receive them by next week, by the end of next week. So I'm like, okay. It's like, sure, I'll wait. So, you know, she said I'll receive all of them. First off, I'm thinking to myself, like, why is the secretary of the judge's lobby involved in this? This is not supposed to be the judge's lobby. This is not supposed to be the judges involved in gathering these tapes together in order for an appeal. So, you know, like Thursday, Friday comes, no new recordings. Monday comes, no recording. Tuesday comes, no recordings. Wednesday comes, no recordings. I decided to give him a call. Once again, I'm transferred to the judge's lobby. No one answers. I leave a message. Thursday comes. I call again. I leave another message. Friday comes. I call again. I leave another message. Then Friday, I call up the administration department of the district court to try to get them involved, because we guys aren't aware of, which maybe I'll be posting this sometime in the future. I had filed charges against my stalker's mother for threatening me years ago, and it went to a show cause hearing. At the show cause hearing, my stalker and my stalker's mother and father all filed for a witness intimidation charge against me as well, because that's why I filed as a witness intimidation charge against the mother for threatening to have me murdered. You know, like, yeah. You know, like, I was suing, like, you know, my stalker as part of the lawsuit bundle I had, you know, back then, you know, against the state agencies. So with that case right there, you know, they filed for witness intimidation charges against me, claiming that when we had left court one day, I had taken a photo of the group of them, and that's what they claimed was witness intimidation. Well, with that right there, I'm glad I did, because I found out that one of the people that was huddled in the group was a director of a program at Westfield State College, and I was suing Westfield State College. Well, Westfield State College was a co-defendant in that lawsuit with my stalker. So that right there tied them all together, and they refused to give me who the guy's name was or anything up until that thing where my stalker said the guy's name, and they worked for Westfield State. And I did the search and found out that he was a director of one of the programs, which tied them in. But even that, you know, like, you know, they tried to say, okay, well, we find cause, you know, that this person threatened you, and then they looked at and said, well, we also find cause that like witness intimidation took place by you taking a photo of the group of them in front of the courthouse. Then they're like, well, we could either let both charges of witness intimidation go forward to trial, or we could drop them both. And I looked at the magistrate. I'm like, hey, look, fine, let's have both go to trial. And then, like, the other person's like, well, I work for the state, and if I get charged with this, I might lose my job. So what the magistrate did in that case was drop both cases. Didn't allow either case to go forward. Well, that magistrate was actually, I believe, Williams, the one who was in the Palmer case, the one who didn't have me come upstairs from the lockup to actually have my motion to dismiss heard that day. And they gave me so she ended up getting a promotion from a magistrate to a judge. Well, also with the Springfield District Court, they refused to give me a copy of that hearing. And I had to contact the district court, well, the administration office of the trial courts, for them to contact Springfield District Court to order them to release that release that audio to me. That's kind of what's going on right now. They do not want me having these audio recordings of the trial and the motion to reconsider and a few other motions as well, because what is said, what the judge says, as well as what the ADA has said, and what I had brought to their attention. So they're not even getting back to me now. And anyone knows anything about appeals knows that they're very time sensitive. So with an appeal, you only have so long to file a brief. So what they're doing right now, by not giving me a copy of the recordings, going on over 2 weeks now, is they're severely limiting my time to file my appeal. Because if I wait too long, my appeal can automatically get rejected. And remember, once I get all these recordings, then it's going to take a while to have a transcript company transcribe them, because that's part of the file. Okay, well, donations can be sent to my P.O. box, which is on the bottom. My mailing is on the bottom. I'm the author of Raw Emotion and Political Repression, The True Tale of Massachusetts Bohemian. So it can be bought through PayPal for $25, shipping included, or on eBay, which is going to cost you a little bit more. And if you buy it person to person, you get an extra bonus. I throw bonuses in as well. Okay, so have a good day. Hopefully you like, hopefully you comment, hopefully you subscribe. I'm not wearing a tinfoil hat here. I'm trying to get a copy of all the recordings to actually prove to you, everyone, all you guys, what's going on. Okay, have a great day.